Imagine you are standing at the podium. The judge is staring down at you, visibly impatient. Your opposing counsel just levied an unexpected, blistering objection during your star witness. Direct examination. Your heart rate is speaking. What is your very next move? The title of this module is Courtroom Skill in Question Document Cases. Courtroom Skills in Question Document Cases. In Nigerian jurisprudence, the sources of cases involving question documents hinges on understanding the intersection of science and the Evidence Act. Whether dealing with a forged land title in a case dispute or a falsified financial ledger in a criminal prosecution, the standard of proof dictates how evidence must be handled. In civil cases, the burden of proof rests on the preponderance of evidence, that is, having greater weight, more convincing, more likely to be true, that is, balance of probability, as per section 134 of the Evidence Act 2011. Also, in criminal cases, the prosecution must prove the guilt of the accused beyond a reasonable doubt. But there is an exception, the forgery exception in civil matters. Crucially, if a civil case hinges on an allegation of crime, such a forgery or fraud, section 135 subsection 1 stipulates that the allegation of the crime must still be proved beyond a reasonable doubt. Let's move on to examination in chief of the document expert. This examination in chief of the document expert, this is the formal examination process where the expert witness presents his qualification, his methodology and findings. And this is the stage of a trial where a lawyer questions their own witness. The primary goal of the examination in chief is to establish the expert credibility and seamlessly tender their report into evidence under section 68 of the Evidence Act 2011. So, examination in chief must be executed step by step, and I'll be taking us through these steps. The first step is qualifying the expert. Qualifying the expert. You have to establish their academic background. Establish their academic background. Their specialized training, e.g., forensic document examination, or their certifications, their years of active experience, and past court appearances, if any, as per of the expert witness. Then the second step is laying the foundation. Have the expert explain the scope of their referral. What documents were provided, which were the question or disputed documents, and which were the known or standard that we call exemplars. Then the third step is tendering the report. What the expert through identify their signature and stamp, if stamp is used, but at least signature must be on the report. So walk the expert through identifying the signature and stamp on the forensic report, then formally tender it to the court. I have a sample of sample questions that may be used. about 5 of them. So it will go like this: to the expert witness from the lawyer. State your name, your profession, and office address for the record. Then after that one, you may still go on and ask, can you briefly outline your specialized training and experience regarding the scientific examination of questioned, handwritten, and documents? After that, you pause and allow him to reply again. Then you ask him, what materials did you use as comparison standards? And how did you verify their baseline authenticity? You pause, you allow him to reply, then you go on again and ask, look at this document. Do you recognize it? What's it? The expert will identify their report. My lord. Then the lawyer will say, my lord, I seek to tender this report as Exhibit A. Those are the sample questions that may be asked during examination in chief. So let's move on to cross-examination. Cross-examination strategies. The strategies that you can use in cross-examination. Cross-examination is the stage of a trial where a lawyer questions a witness by the opposing side. If examination in chief is about letting your own witness build a story up, then cross-examination is about tearing the opponent's story down. It is widely considered the most high-stake, dramatic, and powerful tool in a trial lawyer's arsenal. What are the objectives of this strategy? What are the objectives? The first objective is challenging objectivity, exposing if the expert is just a hired gun who only look at materials provided by one side without demanding broader contemporaneous standard. We made mention of contemporaneous standard in our previous modules, that every time you want to collect a standard, the standard, if it is about handwritten or about maybe you want the expert to examine writings or signature, the standard collected must be contemporaneous one, the one that was created around the time the disputed document was created. So the second objective is exposing insufficient standard. You have to highlight that the comparison sample were too few. If you discover that there was no enough standard that was used, so you have to expose that one. And the purpose of telling the court to exposing, the purpose of making the court to know that the expert used few samples, is to destroy the admissibility of his evidence. Because when the sample you use is not enough, when there's insufficient standard, then you cannot get the result that is reliable. And the standard is to get sufficient standard. As we said in the other lectures, if it is a signature, you get like between 15 and 20. But if it is a handwritings that you want to examine, you have to get several pages of that handwritings. Then the third objective is exploiting natural variation. Exploiting natural variation. So you have to force the expert to admit that no individual writes their signature exactly the same way twice, and that one will make you to lay to build upon it that what probably the report of the expert is saying that there are no similarities between the standard and the disputed. So you want to make it known. You want to make it known to the court that the seeming differences that the expert is pointing to is just natural variation, because in natural variation you see something that seem as differences, but those differences are not real differences. Then we have samples of sample questions that you can use for cross-examination. It will go like this. Mr. Expert, you will agree with me that you did not personally witness the defendant sign the comparison document you use. Then you allow him, pause and allow him to talk. After that, you perform your entire analysis using photocopy of the disputed check rather than the original instrument, correct? That is to expose him that he used photocopy that will not give result that is needed to determine whether the alleged writer write the signature. Then another question that may be asked is it not a scientific fact that stress, illness, medication, or advanced age can cause a person's signature to vary significantly from their usual style? It will, because that is one of the principles. He will have to agree. So that one you can use that one to solidify your point that the differences that he saw, that he made mention, that he's pointing attention to, is caused by medication, assuming there is a reason for you to use that, or advanced age, in a case where you have a will that was made several years back before codice was written. So if you may just use that one, that the reason where you see something that seemingly as different as if they are not the same, as if they are not written by the same person, is just because of the advanced age that has caused the signature of the writer to change. So another question that you may ask is this: you found 3 similarities between the signatures, but you choose to focus almost exclusively on these differences in your report, didn't you? That one also is to destroy the fact that he said there are differences. There are differences in these writings of the disputed and the standard. So because when you want to talk about either difference or similarity, you have to consider the totality of all the differences that you have. The unexplainable differences. The unexplainable differences will give you will help you to say yes, there are differences in this thing because they are not unexplainable. Then you have similarities that are not explainable. So, but one difference or difference in just a feature of the 2 samples that you compare is not enough. So by the time you ask that question and is able to say yes, that means you are telling the court that look, this man is only concentrating on a part and is not using the totality of what he's supposed to use. So let's move on to another aspect. Challenging expert methodology. That one is very, very crucial, because one of the reason, or one of the factors that the court will consider before accepting any expert witness to be a real witness is that the methodology that he used must be sound. He must be able to explain the methodology. If the methodology is not is something that he cannot, that is not in conformity with what has been on ground, then the report may not be admissible. So to succeed, to successfully dismantle an opposition's expert testimony, counsel must also understand the scientific benchmark of question document examination. In Nigeria, for example, the ACEV methodology, that is a analysis, comparison, evaluation, and verification that we have discussed in the previous modules, is widely recognized. So that is, we have different methods, but this is widely recognized because of the fact that it has a structure that anybody can follow and still get the right thing. So then use that methodology. Doing the methodology, you have to raise technical issues. You have to raise some technical issues. So technical issues to raise are this: inadequate magnification. Inadequate magnification. The purpose of that is to tell the judge that he didn't magnify the object enough to see some details, and if those details are not seen, then there's no way you can get what the result is supposed to get. So you have to question whether stereo microscopy was used, or electrostatic detection apparatus was used, or just ask him for what he used for his examination, the equipment that he used for it. So from that you can pick what you need. Another thing is to pinpoint about the instrument used. For example, the way gel point and ball point, the way they write, are never the same. So you may ask a question like whether the expert account for the type of pen used or the rough written surface, if it can be established that the writer or the suspect didn't write the signature, whether he didn't sign it on a table. Maybe whether for example, maybe there's established it is established that he signed it inside the car, or maybe inside a moving car, or in a banking hall where there's no chance for him to put it on a flat surface. So the expert supposed to account for that, because when you write, the surface or the material that you use to write will always affect your writing. So it can affect the quality, the line quality, and if line quality is one of those features in handwritten document that you use to see whether it is forged or not, then let's go to demonstrative presentation. Demonstrative evidence presentation. A document case cannot be won by reading text aloud. The judge must see the forgery. Under Nigerian law, charts and digital projections are permissible to assist the court in understanding complex evidence. What are the best practices for the courtroom? The first, you can use side by side comparison charts. Side by side comparison chart. So in that case, you use enlarged high resolution photographic charts, placing the question signature directly next to the known standard, so that the judge can see the two side by side. And when you are explaining the way your comparison, he or she can be going along with you and understand the message you are trying to pass across. Then another thing that you can use is call out and annotation in your report. Call out and annotation. So in that, you have to use clear arrows. The expert, you have to use clear arrows or boxes to highlight specific microscopic features like pen lifts, tremor, patching, or blunt terminal strokes. This is what I mean. When you are analyzing callouts, and when you are analyzing your result or your examination with chart, using call out and annotation will help you a lot. For example, by that time you have enlarged it. So you enlarge it to a percentage that will be similar to what your audience, that is the court, the judge, will see, the percentage they will see as if they are looking at it under the microscope. So by the time they pick your result, the chart inside your result, and they are looking at it, is as if they are looking at it under the microscope. So use call out and annotation. For example, where you have pen lift, you have to indicate it. You use arrow to indicate it, and tell the court, the reader, the reason why that gap that you call pen lift is there. For example, look at my screen. Look at this example up here. You look at where you have tremor. Look at where we have a pen lift and passion. They are explained using arrow, and at the same time I explain and I also tell the reader the reason and the indication, what those things indicate. Wherever you see pen lift, what it indicates in any document, what the tremor indicates, then what the passion indicates. So this one will help the reader, especially the judge, to understand the message you are passing across when you are trying to tell the court that the signature was forged, or maybe somebody forged another person's writings in any handwritten document. So another method of passing your message across to the court, or your reader to the court this time around, is using digital presentation. In court, infrastructure, if infrastructure of the court allows, then you have to utilize a projector or tablet to zoom into line crossings to show the sequence of strokes, proving if a signature was placed before or after the type test. So that one we make it very clear to them. But when you are just explaining through your report with ordinary tests, it may not be clear. It may not, the understanding may not be clear enough. So the best thing is to use any of this method, side-by-side comparison charts, or call out an annotation inside your report, or using digital presentation if the infrastructure of the court will allow it. Yes, let's talk about handling the opposition report. When faced with an unfavorable report or expert report from the opposing side, the counsel must take deliberate tactical steps to mitigate its impact. I'll be mentioning the step one after the other. The first is to engage a consulting expert. Engage a consulting expert. Do not try to analyze the science alone. No, this is science. Even if you were a science student before you study law, do not try to analyze it alone. Call the expert and do it together. Retain your own expert to review the opposition's report for analytical gaps or flaw in the expert conclusion, in the opposing counsel's witness conclusion. So try as much as possible, do not do it alone. Call your expert and let your expert, you and your expert, do the analysis. Let him guide you. He can read it and see what you not see, and explain to you what you may not understand. He will be able to see from his own point as an expert that this report, this thing is wrong with it, that thing is wrong with it. So that one will help you on how to channel your tender your case better. Then another step in handling the opposition report is to file a rebuttal report. File a rebuttal report. Ensure your expert prepares a comprehensive rebuttal report, clearly articulating why the opposition's findings are scientifically unsound. So you may not see what you will see because the expert is trained and he knows some things that you may not understand. For example, the expert may help you to bring out that they are the inside the report that he didn't write the limitation, despite the fact that he didn't have the original with him. He didn't write. So that one is one of those things you can see. Another thing that you may see that you may not be able to see is the methodology. You may bring out some things from the methodology that is wrong or that is not adequate in the preparation of it of the report. So the third step is objecting to admissibility, and that one is very, very important. Objecting to admissibility. So you check if the opposition's report complies with formal statutory requirements. For example, is it properly addressed to the court or police, or does the author lack verifiable expert credential under Nigerian law? For example, I know maybe when it may just be during the time the expert was signing his report, and he write a designation there instead of question document examiner. He may write something else so that you make it to say no, this person that signed this report is not a question document examiner. Then that one will lead you to query his qualification as to that work. So if you're able to establish that the expert didn't have a verifiable expert credential, then that is a problem for them. So, and that one may make the court to reject him as an expert that can that can come and witness, that can come and witness in that case. So, um, then another, the objecting to admissibility will be easy for you when your expert is able to help you. When you allow your expert to help you to pinpoint to some things that you may not see ordinarily. The most powerful weapon in a courtroom is not a booming voice, but mops and buckets preparation. Knowing the case file better than anyone else in the room.